federal lawsuit against the state of New York's eviction moratorium and declaration of hardship is being heard in the U.S. District Court, Eastern District of New York State this week. During the preliminary injunction hearing, the court has already made it seem apparent as to what its decision will be in this case. And that decision is this is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Landlords, it seems that the decision of this court will be regarding this particular case is that it will dismiss this case. And there's reasons behind that. But first we want to address the lawsuit itself. This lawsuit has great foundation. The verified complaints are very solid in that they state that the challenge to the declaration of hardship that the tenants are signing is illusory. Now, what that means, landlords, is that when you take your case to court to challenge your tenant's certification of the declaration of hardship, because you believe that it is not, that they are not allowed to do that, that they have no foundation to sign that, and therefore you want to take them to court to prove them wrong, is nothing but an illusion. Now, we're not going to get into the meat and potatoes of why that is, as we have a previously released video that we will show a link to at the end of this video, so that you can watch that. But basically, it is you take your tenant to court to challenge the declaration, and the onus of responsibility, the burden of possession and persuasion, falls solely on the shoulders of the landlord, and the tenants just sign the declaration and do not have to bring any evidence, any proof, any documentation to validate their reasoning for signing the declaration of hardship. So this federal lawsuit absolutely has a great basis of argument that this should be tossed out. We fully support it. We fully agree with it. But here is why Judge Gary Brown in the case has made comments in this preliminary injunction hearing that lets our team at the Landlord Advocates firmly believe that this case will be dismissed. And here's why. There are 4 plaintiffs in this case. One is the Rent Stabilization Association, a very large trade organization in New York City that represents thousands and thousands of landlords that own millions of dollars worth of real estate. There are 3 other human plaintiffs in the case. We're not going to name them. The cases on the internet, the web, we're not going to name them because we also do not want to see any tenants trolling them or any organization going after them. We're not going to help those people go after our people. Not going to happen. But the issue that the judge has taken and why we believe the case will be dismissed is that the 3 individuals who have brought forth this case have had issues with the declaration of hardship. In that in their courts of jurisdiction, what that means is the cases where, or the counties or the courts where their individual eviction cases will be heard, to challenge the declaration of hardship to get their tenants out has not happened. That these plaintiffs have not actually brought forth their case to challenge the tenants signing the declaration of hardship. In fact, one of the plaintiffs never even received a signed declaration back from their tenant until after the filing of this federal lawsuit in the U.S. District Court of New York State. How therefore, and when you sue somebody in court, it's because you have been harmed, you have been damaged. You want to be compensated for that damage, no matter what the amount might be, or the solution that you want. It might be to overturn a law. Therefore, your damages, your harm has ceased. The situation with this is that the 3 human plaintiffs in this case cannot prove that they have been harmed, and they cannot prove that they have been damaged, because they have yet to challenge the declaration of hardship in their courts. If they they had done so, then they would have a valid, meaty argument to say, we have challenged this declaration on the basis of, and the court has completely ruled against us. And it should not have because, like we alluded to in a previous case that we had, our team had, when a tenant signed the declaration of hardship in early September, and late September, he did not come to court with the information that we had sought through the information subpoena, the judicial subpoena juris tecum. He did not bring forth the evidence whatsoever to corroborate his claim of a medical health-related issue by signing the declaration of hardship. And the court ruled in favor of the tenant because the landlord could not prove, our team could not prove that the tenant was suffering because the tenant was the custodian of all of the information that would corroborate his argument that he is suffering. And in fact, the tenant never even came to court that afternoon, to even defend himself. And the court ruled in his favor. That would have been a classic case in this lawsuit. Now we have about half a dozen or more that we already have, where the tenants have signed the declaration, we have offered a challenge, and our local courts have said, no, not going to allow it, not going to have it. We have a strong argument that we would be able to assist the Rent Stabilization Association and the law firm that brought this. Our team would be willing to work with them in order to bring forth a case that has some meat to it. Now this case does have very many valid points. We've stated that before. But honestly, and with respect, this case should not have been brought with the plaintiffs that it was, because the plaintiffs did not yet challenge the declaration of hardship in their courts. And there might have been a chance that they would have won that declaration. Probably not. Well, the argument of Judge Gary Brown in the U.S. District Court that he sits in on as the presiding judge would be that you did not even try. We relate that to your child who you put broccoli in front of their face and they tell you, I don't like broccoli, and the parental statement is always, you haven't tried it, so how do you know you don't like it? The child tries it. Mommy, Daddy, that is good broccoli. I didn't realize. The child presented an argument against the broccoli before even trying it to see if it tasted good. In this case here, these human plaintiffs brought forth a case through their law firm, or the law firm that represents them, that they don't like this declaration of hardship because they can't win, when in fact they never even tried. We hope that this case is reintroduced with different plaintiffs or plaintiffs that have actually challenged it, if it is those individual plaintiffs, and that we as landlords do win here in the state of New York, and every state that has seen the oppressions placed upon us by tenants, their allies, and the government. Let's win some here. We need to end this oppression that we have been faced for close to 2 years from governments across the United States. Landlords, we ask that you subscribe to our channel, hit the like button, hit the notification bell. Leave us comments below. Do you believe that this case should have gone through? Do you believe that our assertion is that these plaintiffs were not the right ones to have signed onto this lawsuit? Let us know what you think. Let us know. Until then, landlords, take care.